There is a man in New Jersey. He waited 6 years for his green card. 6 years of applications, interviews, attorney fees, stress and uncertainty. And he got it. He finally got it. He framed the thing, genuinely framed it, and put it on his wall. And then 3 years later, he showed up at his naturalization interview, and the officer pulled up his file and asked him one question. Why did you leave the United States for 7 months in 2022 without a re-entry permit? And just like that, 6 years of waiting, 3 years of being a permanent resident, and one framed green card on the wall meant almost nothing, because nobody told him that the card in the frame came with a list of responsibilities that USCIS was quietly tracking the entire time. That man is not unusual. He is what happens when someone wins the hardest part of the immigration process and then assumes the rules stopped applying to them. They did not stop, they never stop. And today, I am going to walk you through the 8 things USCIS expects you to do after you get your green card. Because the people who don't know this list are the ones who end up losing everything they spent years building. Let me paint you a picture that is going to feel uncomfortably familiar to a lot of people watching this right now. You have been in the immigration process for somewhere between 2 and 7 years, maybe longer. You have gathered documents you did not know existed. You have attended interviews that kept you up the night before. You have paid filing fees that made your bank account wince. You have waited, and then waited some more. And then one day the envelope arrives or the notice appears in your USCIS online account, and it is approved. Your green card is approved. And for one genuinely beautiful moment, the weight of all of those years just lifts. Completely lifts. And you deserve that moment. You earned it. Take it. Enjoy it fully. And then I need you to come back. Because what happens next is the part nobody prepared you for. Here's what USCIS does not tell you when your green card is approved. They do not send you a checklist. They do not schedule a follow-up appointment. They do not assign you a caseworker who calls you 3 months later to make sure you are meeting your ongoing obligations. What they do is approve your card, mail it to you, and then quietly begin a new chapter of your file. A chapter where your behavior as a permanent resident, your tax filings, your travel patterns, your address updates, your selective service registration if applicable, all of it gets documented. Not loudly, not with warnings, just documented. And that documentation sits in your file, waiting for the day you apply for citizenship, at which point an officer is going to open that file and review everything that happened from the moment your green card was approved to the moment you sat down across from them at your naturalization interview. Most green card holders have absolutely no idea that chapter is being written, and that is the problem. Let me tell you what freezing actually looks like in practice, because it does not always look like doing nothing. Sometimes it looks like doing the wrong things confidently. I have seen people, genuinely smart, hardworking, well-intentioned people who got their green card and then did things that seemed completely logical in the moment but created serious complications later. They traveled internationally for 8 months to visit a sick parent without getting a re-entry permit because nobody told them there was a 6-month rule. They filed their taxes the same way they always had, as a non-resident, because they did not realize that your tax filing status changes the moment you become a permanent resident. They moved to a new apartment and did not update their address with USCIS because they figured the post office forwarding was enough. It is not enough. None of those things are enough. And each one of them created a problem that showed up later, at the worst possible time, in the most inconvenient possible way. And here is the part that I think people genuinely do not understand about how USCIS works. The system is not designed to catch you in real time. It is designed to document in real time and evaluate later, which means you can be making mistakes for years without any immediate feedback, without any warning letter, without any indication that anything is wrong. Your green card still works, you can still travel, you can still work. Life continues normally. And then you apply for citizenship and the officer opens your file and suddenly all of those undocumented moves, all of those missed filings, all of those technical violations that seemed minor at the time are sitting right there in black and white, creating questions you do not have clean answers to. That delayed feedback loop is what makes the post-green card period so dangerous for so many people, because the human brain is wired to respond to immediate consequences. If touching a hot stove burned you 3 years later instead of immediately, a lot more people would touch hot stoves. The immigration system is essentially that hot stove. You touch it today, you feel it at your naturalization interview. And by then, the options for fixing it are significantly more limited and significantly more expensive than they would have been if you had just known the rules on day one. Now, I want to address something that I hear constantly and that I think is worth dealing with directly before we go any further. A lot of green card holders, particularly people who went through long and difficult immigration processes, develop a very understandable psychological response to finally getting approved. They do not want to think about immigration anymore. At all. The process was stressful, it was expensive, it was uncertain, and now that it is over, they want to put the whole experience behind them and just live their life. I completely understand that. I genuinely do. But that response, as understandable as it is exactly the mindset that leads people into the mistakes we are talking about. Because the immigration process is not over when your green card arrives. It is just entering a different phase, a quieter phase, a phase with fewer deadlines screaming at you from every direction. But a phase with rules just as real and consequences just as serious as anything that came before. Think of it this way. Getting your green card is like getting your driver's license. The test is over. The hard part of proving you qualify is behind you. But the rules of the road did not disappear the moment you pass the test. Speed limits still apply. Stop signs still apply. And if you drive around for 3 years ignoring those rules because you were so relieved to have your license that you stopped paying attention, the consequences catch up with you eventually. The green card is your license. The road rules are everything we are about to talk about. And here is something that should genuinely motivate you beyond just avoiding problems. Every single one of the 8 things USCIS expects you to do after getting your green card is also a building block toward your citizenship application. When you do these things correctly, consistently, and on time, you are not just staying compliant. You are building the strongest possible naturalization case. You are creating a file that an officer can open and see a clean, consistent, responsible record of someone who took their responsibilities as a permanent resident seriously from day one. That is the file that gets approved smoothly. That is the file that does not generate extra questions at the interview. That is the file that turns a 6-year immigration journey into a successful citizenship application without any last-minute surprises. So when I say the celebration is earned and the paperwork never stops, I am not trying to dampen anything. I am trying to make sure that the celebration you had when you got your green card gets followed by an even bigger celebration when you become a citizen. And the path between those 2 moments runs directly through the 8 things we are about to cover. Now, before I get into each one specifically, I want to be clear about something. The 8 responsibilities we are going to discuss are not equally weighted. Some of them are administrative, meaning they are important, but the consequences of getting them wrong are manageable if you catch the mistake early. Others are what I would call foundational, meaning they go to the very core of your eligibility to remain in the United States as a permanent resident, and getting them wrong can have consequences that no attorney can fully fix after the fact. I am going to tell you which is which as we go through them, because knowing the difference helps you prioritize correctly when life gets busy, and you cannot do everything perfectly at the same time. Which, by the way, is going to happen. Life is going to get busy. You are going to have months where the last thing on your mind is an USCIS form. You are going to have moments where you think, I will deal with that next week. And next week turns into next month. I am not here to pretend that does not happen because it happens to everyone. What I am here to do is make sure that when those busy seasons hit, which things absolutely cannot wait and which things have a little more flexibility. Because that knowledge, that specific prioritization, is the difference between a minor administrative catch-up and a serious immigration problem. So take a breath. You got your green card. That is real and it is significant and it deserves every bit of the pride you feel about it. And now let's make sure you keep it, build on it, and turn it into the citizenship you have been working toward all along. Let's talk about what USCIS actually expects from you starting right now. Okay, so I want to start this section with a confession that I think is going to resonate with a lot of people watching this. When most people receive their green card, somewhere in the back of their mind, they start thinking of themselves as American. And honestly, that feeling makes complete sense. You live here, you work here, you pay taxes here. You have been through a process that frankly most actual citizens could not survive, because most actual citizens have never had to prove their eligibility to be in the country they were born in. You have earned your place in this country in a way that goes far beyond a piece of plastic in your wallet. So the feeling of being American is real and it is valid and nobody should take it from you. But the legal reality is more complicated than the feeling. And the gap between how green card holders feel and what the law actually says about their status is where some of the most serious and most avoidable mistakes in the entire immigration system happen every single year. So let us close that gap right now, completely and clearly. Because understanding exactly where the line is between permanent resident and citizen is not just an academic exercise. It is practical protection for everything you have worked to build. Let me start with the one that surprises people the most and that carries the most serious consequences: voting. I know this seems obvious. I know you are probably thinking, I would never vote. I know I am not a citizen. And I believe you. But here's the thing. The mistake almost never happens because someone deliberately decides to vote illegally. It happens because the systems that are supposed to catch it do not always work the way people assume. Voter registration forms are often distributed automatically at DMV offices when people apply for or renew their driver's license. In some states, the form is handed to you as a matter of routine, and the question about citizenship eligibility is buried in the middle of a document that most people skim rather than read carefully. A green card holder who is not paying close attention can accidentally check the wrong box, register to vote without fully realizing what they have done, and in some cases even cast a ballot without understanding the full legal implications of what just happened. And I want to be very clear about what those implications are because they are not minor. Voting as a non-citizen is a federal crime. It can result in deportation, it can result in a permanent bar to naturalization, it can result in criminal prosecution, and it can happen to someone who made an honest mistake on a form they were handed at the DMV without any malicious intent whatsoever. The law in this area does not always make generous room for honest mistakes. Which means the protection against this consequence is not good intentions. It is knowing the rule so clearly that the mistake never happens in the first place. If you are a green card holder, you do not vote. Not in federal elections, not in state elections, not in local elections, not even in elections that seem minor or unofficial. You do not vote until you are a citizen. Full stop. Mark that in whatever part of your brain stores the non-negotiable rules, and do not revisit it until your naturalization certificate is in your hand. Now let us talk about jury duty, because this one plays out differently and in a way that trips people up in the opposite direction from voting. With voting, the danger is accidentally participating. With jury duty, the danger is a combination of accidentally participating and accidentally lying about your status to avoid participating. Here's how it typically unfolds. A jury summons arrives in the mail. The green card holder looks at it and thinks correctly that they are not supposed to serve on a jury because they are not a citizen. So far, so good. But then they look at the form they need to fill out to be excused, and they see a checkbox or a question that asks something like, "Are you a United States citizen?" And they check no, which is correct. But here is where some people make a catastrophic error. In a panic or out of confusion or because someone gave them bad advice, they check yes on that form thinking it will get them out of jury duty faster or avoid drawing attention to their immigration status. That single check mark is a federal crime. Falsely claiming to be a United States citizen on any official government document, including a jury duty response form, can result in permanent inadmissibility, deportation proceedings, and a lifetime bar to naturalization. This is not a technicality that immigration attorneys can argue around after the fact. It is one of the most serious misrepresentation findings that exists in immigration law, and it happens, genuinely happens, to real people who were just confused about how to handle a jury summons and made a split-second decision that changed the entire trajectory of their immigration case. The correct way to handle a jury summons as a green card holder is straightforward. You respond to the summons. You indicate honestly that you are not a United States citizen. You provide your green card number if requested. And you can petition for certain family members to join you in the United States. Your spouse and your unmarried children under 21 are petitionable as immediate relatives of a permanent resident. The process is longer and more complex than it would be if you were a citizen because your family members are subject to visa bulletin wait times rather than immediate visa availability. But the ability to begin that process, to start building toward having your family with you in the same country is real. And it starts the day your green card is approved. Do not wait to look into this if it applies to your situation. So the picture of permanent residency is genuinely complex. There are real restrictions that carry serious consequences if you ignore them. And there are real rights and freedoms that you are entitled to use and that make your life in the United States significantly more stable and more expansive than it was before. Understanding both sides of that picture completely is what allows you to move through your permanent residency years confidently, legally, and in a way that builds toward the citizenship you are working toward rather than quietly undermining it. Because here is the truth that I want to leave you with before we move into the 8 specific things USCIS expects you to do. The path from green card to citizenship is not just about waiting out the clock. It is about how you live during that waiting period. Every decision you make, every form you fill out, every year you file your taxes correctly, every address update you submit, every trip you take within the legal limits, every jury summons you respond to honestly, all of it is building the record that your naturalization officer is going to review. You are not just waiting to become a citizen, you are demonstrating every single day that you deserve to be one. And that demonstration starts right now with understanding exactly what your green card does and does not allow you to do. Now let us get into the 8 specific things USCIS expects from you, because this is where the general understanding we just built turns into concrete action steps that you can take this week, this month, and over the coming years to protect your status and accelerate your path to citizenship. Point 3, expanded. The 8 post-green card filings are not optional, they are a timeline. All right, this is the section you actually came here for, and I want to be upfront with you before we dive in. I'm going to walk you through 8 specific things that USCIS expects every green card holder to do, file, maintain, or comply with after their card is approved. Some of these have hard deadlines that cannot be missed under any circumstances. Some have softer timelines that still matter but give you a little more room to work with. And some are ongoing obligations that do not have a single deadline, but that require consistent attention for the entire duration of your permanent residency. I'm going to tell you which category each one falls into as we go, because knowing the difference is genuinely important for managing your life as a permanent resident without losing your mind in the process. And before anyone asks, yes, I know some of these vary by state and by individual circumstance. Immigration law is not a one-size-fits-all system, and I am not your attorney. What I am is someone who wants you to walk away from this video with a clear enough picture of what is expected that you can have an intelligent, informed conversation with a qualified immigration attorney about your specific situation. Think of this as the map. The attorney is the GPS that accounts for the specific road conditions of your particular case. You need both. Now let's get into it. The first thing, filing your taxes as a resident. I am starting here because this is the one that surprises people the most. And that has consequences reaching far beyond just the tax system. The moment you become a lawful permanent resident of the United States, your tax filing obligation changes fundamentally. You are no longer a non-resident alien for tax purposes. You are a resident. And that distinction matters enormously in ways that catch people completely off guard. Here is what changes. As a permanent resident, you are required to report your worldwide income to the IRS, not just your income from the United States, your worldwide income. If you have rental income from a property in another country, if you have a bank account overseas that earns interest, if you receive income from a foreign business, all of it is now reportable to the IRS under your new resident status. This is not optional. It is not something that only matters if you earn above a certain threshold in the foreign country. It is a legal obligation that begins the tax year in which you become a permanent resident, and here is the immigration consequence that most people do not connect to their tax filing. When you apply for naturalization, USCIS will ask you whether you have filed your taxes as a resident for every year of your permanent residency. They will ask to see your tax transcripts. If you have been filing as a non-resident during years when you were legally required to file as a resident, that discrepancy is a problem. Not just with the IRS, with USCIS, because it raises questions about your understanding of and commitment to your obligations as a permanent resident, which is directly relevant to whether you demonstrate the good moral character requirement for naturalization. The fix is straightforward, but it requires action now, not later. If you have not already, contact a tax professional who understands the intersection of immigration status and tax filing obligations. Make sure every return you file from the date of your green card approval correctly reflects your resident status. And if you have already filed incorrectly for a previous year, an amended return is almost always better than leaving the error in place. That is filing obligation number 1, and it recurs every single year without exception. The second thing, updating your address with USCIS within 10 days of moving. I know what you are thinking. Really? Address update? That is on the list? Yes, it is on the list. And it is on the list because it is legally required and because the consequences of not doing it are more serious than the administrative simplicity of the task would suggest. Federal law requires every non-citizen in the United States, including lawful permanent residents, to notify USCIS of any change of address within 10 days of moving. 10 days. Not when you get around to it. Not after you have unpacked all the boxes and figured out where you put the good scissors. But a phase with rules just as real and consequences just as serious as anything that came before. Think of it this way. Getting your green card is like getting your driver's license. The test is over. The hard part of proving you qualify is behind you. But the rules of the road did not disappear the moment you passed the test. Speed limits still apply. Stop signs still apply. And if you drive around for 3 years ignoring those rules because you were so relieved to have your license that you stopped paying attention, the consequences catch up with you eventually. The green card is your license. The road rules are everything we are about to talk about. And here is something that should genuinely motivate you beyond just avoiding problems. Every single one of the 8 things USCIS expects you to do after getting your green card is also a building block toward your citizenship application. The 10-minute address update is not about bureaucratic compliance for its own sake. It is about making sure the line of communication between you and the agency that controls your immigration status stays open and accurate at all times. Also worth knowing, if you received your green card through VAWA, the Violence Against Women Act, you do not submit the AR-11 online. You send a written notification to the Vermont Service Center specifically for confidentiality reasons. That is a specific exception that applies to a specific group of people, and if it applies to you, please make sure you are using the correct process. The third thing, monitoring and renewing your green card before it expires. This one sounds obvious until you realize how many people let it slip and then find themselves in a genuinely uncomfortable situation at an airport, at a job interview, or at a government office trying to explain why their identification document expired 6 months ago. There are two types of green cards, and they have very different expiration situations. If you received a conditional green card, which is a 2-year card, typically issued to people who obtained residency through marriage to a U.S. citizen, when the marriage was less than 2 years old at the time of approval, your situation is the most time-sensitive on this entire list. You must file the I-751 petition to remove the conditions on your residency within the 90-day window immediately before your card's second anniversary, not after, not whenever you get around to it. Within that specific 90-day window. If you miss that window, USCIS can terminate your permanent resident status. I want you to read that sentence again. They can terminate your status, not delay it, not fine you. Terminate it, which means the green card you waited years to get can essentially disappear because you missed a filing deadline on the back end of it. The I-751 requires you to demonstrate that the marriage through which you obtained your residency is genuine and ongoing. It typically requires joint financial documents, evidence of shared life, and in most cases a joint filing with your spouse. If your marriage has ended, if you have experienced domestic violence or abuse, or if your spouse has passed away, there are waiver options available that allow you to file independently. But those waivers have their own documentation requirements and their own complexities, and if any of those situations apply to you, please do not try to navigate it alone. Get an attorney involved as early as possible. For those of you with 10-year green cards, the timeline is less immediately urgent, but no less important. You should begin the renewal process using Form I-90 approximately 6 months before your card's expiration date. USCIS processing times fluctuate, and 6 months gives you enough buffer to handle any delays without finding yourself in the position of having an expired card. While your renewal is pending, USCIS will issue you a receipt notice that serves as evidence of your continued valid status, but carrying an expired card with a receipt notice is a more complicated situation than simply having a valid card. Start the renewal early. It is not worth the stress of cutting it close. The fourth thing, selective service registration for males between 18 and 26. Okay, this is the one that the guys in the audience need to pay very close attention to because this is one of those requirements that operates quietly in the background and then suddenly becomes very loud and very consequential at naturalization time. If you are a male and you received your green card between the ages of 18 and 25, you are required by federal law to register with the Selective Service System. The Selective Service is the program that maintains a list of people potentially available for military service in the event of a national emergency. Registration does not mean you are joining the military. It does not mean you will be drafted tomorrow morning. It is a registration requirement, and it applies to nearly all male residents of the United States in that age range, regardless of immigration status. Here is the immigration consequence that makes this matter so much. When you apply for naturalization, USCIS will ask whether you registered for selective service if you were required to do so. If you were required to register and you did not, it creates a finding that can affect your good moral character determination, which is a required element of naturalization eligibility. And unlike some other things on this list that can be fixed with an amended filing or a corrected form, selective service registration has a hard age cutoff. If you are now over 26 and you did not register during the required window, you cannot go back and fix it retroactively. You can only explain the circumstances and hope the explanation is sufficient, which is a much more uncertain position than simply having registered when you were supposed to. Most people are automatically registered through other government processes, particularly through the driver's license application at the DMV in most states. But automatic does not mean guaranteed. If you are or were in the 18 to 26 male age range when you received your green card, go to the Selective Service website right now and verify your registration status. It takes 2 minutes. The alternative of finding out at your naturalization interview that you were not registered is a conversation nobody wants to have. The fifth thing, maintaining physical presence requirements. This is the one that the man in New Jersey from our opening story did not know about. And it is the one that I think carries the most risk for the most people because it involves something that feels completely innocent, visiting family in another country, and turns it into a potential immigration problem through a mechanism that most green card holders have never heard explained clearly. Here's the rule in plain language. As a lawful permanent resident of the United States, you are expected to actually live in the United States. I know that sounds circular, but it is the foundation of everything else. The green card is not a travel document that lets you live wherever you want and visit the US whenever you feel like it. It is evidence of your permanent residency, meaning the United States is supposed to be your permanent home, and USCIS has specific thresholds that define when your absence from the country starts to raise questions about whether you have abandoned that residency. Any single trip outside the United States that lasts less than 180 days is generally fine with no additional requirements. You leave, you come back, your green card is intact, no issues. But the moment a single trip extends to 181 days or more, you have crossed into territory where Customs and Border Protection has the legal authority to question you aggressively about your residency when you return. They can ask where you live, where you work, where your family is, where you file your taxes, and whether you genuinely consider the United States your permanent home. And they can make a finding that you have abandoned your residency right there at the port of entry, not eventually, right there, which means you could land at an American airport after 7 months abroad, green card in hand, and be told that your permanent residency is no longer valid. If you know in advance that you need to be outside the United States for more than 6 months, there is a document called a re-entry permit that you can apply for before you leave. The re-entry permit is filed on Form I-131, and it must be applied for and approved before you depart because you have to be physically present in the United States for USCIS to process your biometrics as part of the application. A re-entry permit generally allows you to remain outside the United States for up to 2 years without triggering the abandonment presumption. It is not a permanent solution, and it does not guarantee re-entry, but it is dramatically better than leaving without one and hoping nobody at the border asks difficult questions. And for naturalization purposes, the physical presence calculation goes even deeper. To apply for citizenship through the standard 5-year path, you must have been physically present in the United States for at least 30 months out of the 5 years immediately preceding your application. Every day you spend outside the United States counts against that 30-month requirement. So even if your individual trips never hit the 180-day threshold, a pattern of frequent extended travel can quietly erode your physical presence total to a point where you are not eligible to apply for citizenship when you thought you would be. Keep track of your travel, write down the dates, know where you stand against the 30-month requirement. It is your responsibility to know this, and USCIS will not remind you. The 6th thing. Carrying your green card at all times. I am going to be honest with you. This one has the least dramatic consequence of anything on this list, and it is also the one most likely to generate a comment from someone saying, "I have never carried mine and nothing bad happened." And that is probably true for most people most of the time. But the legal requirement exists, and I would be doing you a disservice not to mention it. Federal law requires lawful permanent residents to carry their green card on their person at all times. Failure to do so is technically a misdemeanor. In practice, the most likely real-world consequence is an inconvenient interaction with law enforcement or a federal officer during which you cannot immediately produce your immigration document and have to explain your status without physical evidence in hand. For most people in most situations, this resolves without serious consequence. But for some people in some situations, it creates a complication they did not need. The card is small, your wallet is right there, carry it. It costs nothing, and the insurance value of having it when you need it is worth the minor inconvenience of making it a habit. The 7th thing, avoiding criminal conduct that triggers immigration consequences. I want to handle this one carefully because I am not here to lecture anyone about behavior, but I am here to be honest about something that immigration attorneys see regularly and that most green card holders genuinely do not understand going in. The criminal justice system and the immigration system overlap in ways that are not intuitive and that can produce consequences far out of proportion to what the criminal sentence itself would suggest. Here is the framework. There are certain categories of criminal conviction that make a lawful permanent resident deportable, regardless of how long they have been a resident, and regardless of how otherwise clean their record is. These are called aggravated felonies under immigration law, and the list of what qualifies as an aggravated felony for immigration purposes is significantly broader and more surprising than most people expect. Crimes that might result in a relatively minor criminal sentence can constitute aggravated felonies under immigration law and trigger mandatory deportation with no opportunity to apply for relief, no hearing, no discretion, mandatory removal. Additionally, there are crimes involving moral turpitude, a legal term that covers a broad range of offenses involving dishonesty, fraud, or conduct contrary to community standards that can affect your naturalization eligibility even if they do not result in deportation. A conviction for a crime of moral turpitude within 5 years of receiving your green card can be a complete bar to naturalization. And the definition of what constitutes a crime of moral turpitude is determined by immigration law, not by how the crime is classified in the state criminal code where you were convicted. This is not meant to frighten you. The overwhelming majority of green card holders never have a criminal justice interaction that triggers any of this, but the reason I am mentioning it is that people who do find themselves in this situation are almost always completely blindsided by the immigration consequences because they were focused entirely on the criminal case, and nobody told them that the two systems talk to each other. If you are ever in a situation where you are being investigated for or charged with any criminal offense, please tell your criminal defense attorney that you are a lawful permanent resident immediately. That information must inform the defense strategy from the very beginning, because a plea deal that seems like a good outcome in the criminal case can be an immigration catastrophe if the specific charge triggers deportability. You need both systems accounted for from day one. The eighth thing: filing for citizenship as soon as you are statutorily eligible. And here is where everything comes full circle, because the single most effective thing you can do to protect your green card is to stop being a green card holder as quickly as you legally can. I mean that genuinely, and I want to explain why. Every obligation on this list, the physical presence requirements, the address updates, the selective service registration, the carry requirement, the criminal conduct restrictions, almost all of it either disappears or becomes significantly less consequential the moment you become a United States citizen. Citizens cannot be deported for criminal convictions in the same way permanent residents can. Citizens do not have physical